Hello, I'm Matthew Kamika, and today I'll be speaking about the social justice framework of prisoners' rights. More specifically, I'll be speaking about segregation. So up for today, our outline is identifying the problem, prominent social movements. We have an activity of a trauma-informed correctional workshop. We have the counter-arguments and a brief reflection. So what is segregation? At this point, I would ask the class if they could name and describe a type of segregation that maybe they've heard of in other classes or know about through readings. Hopefully somebody would answer and we would get the two types, administrative and disciplinary segregation. A brief summary of those is administrative segregation is usually administered on a voluntary or involuntary basis, which is used to maintain security in the event that inmate pose threats to themselves or others. This type of segregation has no time limits to how long you can be in it, whereas disciplinary segregation is used to punish inmates for violating prison rules and procedures for a maximum of 30 days. We know that segregated inmates are usually restricted to 2 hours per day outside their cell with no guaranteed interaction from others. Inmates also placed within segregation do not benefit from rehabilitative programming, mental health supports, or other interventions. But how many of us know about Bill C-83? This bill is really an amendment to the Corrections and Conditional Releases Act, which is the current act governing the use of segregation within our prisons. So what changes under Bill C-83? First off, we have the elimination of the use of administrative segregation and disciplinary segregation. And the addition of structured intervention units. Now, these units are created within existing facilities and are used for the confinement of inmates who cannot be maintained in the mainstream inmate population, whether that be for security or other reasons. Within these SIUs, or structured intervention units, inmates will have the access to rehabilitative program, other interventions, and mental health care. Inmates will also be given 4 hours a day outside their cell as opposed to the previous 2 hours, and at least 2 of those hours are used to interact meaningfully with others. This bill came into effect November 30th, 2019, and is currently implemented throughout all of our prisons. The bill and the SIUs were really intended to provide more structured and effective interventions to inmates who need their specific needs to be addressed, with a goal of facilitating their reintegration into mainstream inmate populations as soon as possible. Now, an article written by Senator Kim Pate for the Globe and Mail does name some concerns where Senator Kim Pate, who was an executive director for the Canadian Association of Elizabeth Fry Societies representing Ontario, was appointed to the Canadian Senate in 2016. She does criticize the use of SIUs as a rebranding of the prior older segregation system. She criticizes these SIUs as an easy way out to managing mental health issues that should be addressed through community supports instead of confinement. She also criticizes the premise of an argument that 22 hours of isolation a day equating to segregation, whereas 20 hours under the same conditions does not. However, this can be seen to draw back to the United Nations Mandela Rules for the treatment of prisoners. I could ask the class, does anybody have anything to say about Mandela Rules? You guys know what it is. Hopefully somebody would answer. I know in other courses we learned that Mandela Rules state that maximum time in segregation should be 15 days cumulative. However, the Mandela Rules also state that prolonged solitary confinement is defined as confinement of prisoners for 22 hours a day without meaningful contact or for more than 15 days. So the change to 20 hours a day really follows in line with the Mandela Rules of not being considered isolation. More on that later. So another organization that criticizes the use of the SIUs as opposed to the old segregation model is the Campaign for the Abolition of Solitary Confinement. This is a voluntary organization group that works for the complete abolition of solitary confinement in Canadian prisons, whether that be federal or provincial. They themselves are unconvinced that structured intervention units are actually not solitary confinement, and so solitary confinement has been abolished within the Canadian system. They state that while the language has changed, there is nothing in the new bill that really addresses problems concerning how new measures will be implemented, that the 2 additional hours outside of the cell will actually help to reduce mental deterioration and the worsening of mental illnesses, and that abuses that were seen prior to the new SIUs, so abuses that were usually held within the old segregation model, would not occur without implementation of independent oversight. They do also list some recommendations to be added to the bill, such as exception of inmates under 25 years of age, meaning that people under age of 25 should not be held within SIUs or within any solitary confinement, and the exception of inmates with mental illnesses as well. Some issues within the Canadian system. Well, we do know that since solitary confinement and segregation can really make mental illnesses worse, we have some figures here. So every day in provincial corrections, about 575 inmates are held in solitary confinement, with 70% of them being legally innocent. Does anybody in the class really know what that means? There's a word I'm looking for. It's being held in remand. So a lot of these people held in remand have either not been tried or have not been sentenced, and so they are held within prisons and they are held in solitary confinement, which really shouldn't be happening. Of course, we also know in 2013 only about 3% of 4,000 correctional staff respondents to the survey or study were properly trained to deal with mentally ill offenders, and that in 2016 about 25% of all use of force incidents were involving mentally ill offenders with the correctional officers. So we can see there that there's a problem with not enough officers being trained to deal with mentally ill, and a correlation between the use of force on these people. Also, not 40% of suicides happen within solitary confinement, so that can go to show the worsening of mental illnesses to that point. So next we have our key activists and organizations. First up we have Justice for Sully. So Sully is short for Solomon. Solomon Fouquier was actually a student studying environmental engineering at the University of Waterloo. However, he was in a car accident in his first year and actually developed schizophrenia, where he had to drop out of school, and unfortunately he got into a lot of trouble with the law while trying to keep up on top of his medication. He did end up dying in prison with his hands tied behind his back, and his hands and feet tied behind his back, and he was pepper sprayed twice by correctional officers. So he died in a altercation with officers. There isn't a lot of info published about this because the Correctional Services Canada is holding it close to their chest. In the picture, we do have Yusuf Fouquier, which was Solomon's brother. This organization is fighting for the prohibition of mentally ill offenders in solitary confinement and prisons as a whole. They're also advocating for correctional officers to have trauma training and mental health training, as well as government to be transparent and be held accountable about their practices, trainings, and deaths, as the family has not yet received meaningful information or reports on the death of Solomon. Next, we have trauma-informed corrections. Now, trauma-informed corrections is a new type of implementation on training and how to deal with vulnerable groups. So we know there's high consensus within research that a large percentage of men and women involved in our justice system have experienced severe trauma within their lives. These experiences of trauma pose significant barriers to accessing services regarding mental illness, housing, and recovery services, and they actually increase the risk of coming into contact within the criminal justice system. So training in trauma can lead to more empathy and understanding when dealing with people with severe mental illnesses, and will actually allow for interactions with people that can help them engage in the services they need, help them engage in the programming within the correctional systems, and can actually avoid re-traumatizing them and adding to self-harm or violence against others. Trauma-informed corrections have also been shown to reduce disciplinary infractions in prisons and reduce the need and use for restraints and segregation, which actually has been shown to reduce injuries associated with, restraining these inmates, which can actually reduces the risk of injury to officers, other staff, and the inmates themselves. So on the slide, we have the 5 pillars of trauma-informed corrections. These are safety, trustworthiness, choice, collaboration, and empowerment. So for safety, you want to create a safe space where people feel safe emotionally and physically, and you want to be aware of any unease or discomfort within the other person. Trustworthiness, really, you want to build rapport and you also want to give info on what exactly is going to happen next, because if people know what's going to happen, they'll be more calm and collected. Whereas choice is recognizing the person's choice and giving them options of complying that will honor their individual dignity. Of course, choice, when you're told to do something by a correctional officer, there's really no choice, but you can give them choices as what can happen regarding their situation that will keep their dignity intact. Collaboration is also keeping in mind what they would like to happen. So instead of giving demands, you could actually share decision making. Also, empowerment would be providing smaller tasks for these inmates to accomplish, which are easily accomplished, that they can succeed at and will eventually empower them. Here we have some examples of trauma-informed correctional speech and way to speak. So, for example, instead of demands such as step away from the desk or hands up against the wall, you can use language such as hey there, let's talk about this, or how can I help you today? It would really be beneficial if we could do it this way. For our group activity, we would be having a trauma-informed workshop. Next, we have the Yukon model. So, as opposed to really using these structured intervention units and keeping with segregation, the Yukon model is a model of reform where the Yukon territory has embraced the Mandela rules, as we have spoken of before, where 15 days of solitary confinement is their maximum, with a maximum of 60 days out of 365 days a year being held in solitary. They've also banned the use of solitary confinement for pregnant women, the mentally ill, people engage in self-harm or suicidal behaviors, as well as the mentally handicapped. So instead of reform, we have abolition. The College of Family Physicians in Canada have actually stated that they are on board with the abolition of solitary confinement. They do argue that the Nelson Mandela model has no basis for 15 days of solitary confinement with a maximum of 60 days out of a year. They state that after a 48-hour point of being held in segregation, health problems can occur. They do believe that instead of treating mentally ill peoples in the correctional system, that these people should not be held in prisons and actually be sent to medical facilities. They also list 7 recommendations for how this can be implemented, with the most of them stating that, of course, mentally ill should not be held in segregation or prisons at all. Neither people with disabilities, and segregation is not an adequate method or for healthcare. Lynn McDonald, who is part of the campaign for abolition of solitary confinement, as noted above, notes that there should be no reason why we cannot abolish solitary confinement, as we have previously abolished capital punishments, bread and water diets, hard labor, water torture, and a bunch of other things that at the time of their implementation were the norm and seen as necessary. Our counter-arguments. So we have 3 counter-arguments. Number 1, the criminal and penal reform is far too costly to implement. Number 2, segregation is necessary for our criminal justice system to deal with mental illness, terrible, horrible, horrific crimes and violent persons, as well as a correctional officer's job is inherently dependent on the current power structure. So our first debunk is our economics. So of course, with the myth being that it's too costly to reform the correctional system, we have some numbers here. So the average cost of an inmate in Canada is $120,000 a year coming out of taxpayer money to keep them in prison, whereas segregation is an average of $200,000 a year. So with that being said, we also have the Office of the Parliamentary Budget Officer releasing a report, whereas in the 2016-2017 year, having a person held within segregation costs over $1,000 a day. So by abolishing and getting rid of segregation, this money would not have to be spent there. We could use money to be spent within other programs, so within mental health programming, within educational programming that will actually help these prisoners more than just placing them in a cell by themselves. We also know that this money doesn't have to be spent within the correctional system. We can use them within the community, as Senator Kim Pate has wanted, where instead of dealing with the mentally ill within corrections and sending people within the correctional system, we can help them within the community. We also know that Canada battles about $20 million of human rights abuse cases in 2019. So these abuse cases are usually held within people within segregation for just abnormal amount of days. So they sue, they get money, human rights abuses. So by getting rid of segregation, these costs wouldn't be costing us. Debunk number 2, segregation as a necessary tool. Well, some people say that segregation is necessary to deal with the mentally ill and these violent offenders. However, we know that trauma-informed corrections have been seen to ease these tensions. They were actually used successfully at the Grand Valley Institute for Women in Kitchener, although the program has fallen out of use since. We know that dealing with the mentally ill or inside segregation cells is not an effective way of dealing with them, especially with the lack of programming available. So it should really be abolished. Our debunk number 3, correctional officers as policy enhancers. So trauma-informed corrections, again, ease tensions. So this training really establishes and eases the amount of violence. So it is seen to make the jobs of correctional officers easier, whereas it makes the job safer because, of course, if you ease tensions, if you follow the 5 pillars above, these people in that these inmates that the correctional officers deal with are less likely to be aggravated, aggressive towards and if they follow the trauma-informed correctional guidelines. That way, programming also becomes more effective, and the correctional officers will not need to rely on the power structure of correctional officers being up here and inmates being down here. Instead, they can rely on effective communication where they're both at eye level. Again, the transparency and safety of inmates shouldn't trump all power structures. All right, so where do we go from here? We have a new bill, Bill 6, which has reached royal assent in 2018 and is currently sitting on the Premier of Ontario's desk, Doug Ford. So while this bill does not incite complete abolition, it does follow the Yukon and UN Mandela rights model. So it allows for 25 days of maximum time held in solitary confinement instead of the 60 days maximum of the whole year. It also states that no segregation should be held for the mentally ill, the pregnant, and the mentally handicapped, as well as different laws for women regarding the strip searches. Of course, women officers should be the only ones strip searching women, as well as a reduction in that practice, as it can be seen as taking away someone's dignity. So what next? What can we do? Really, there's not much we can do as a person. We've already advocated. You can continue to advocate, but we've got the bill to where it needs to be. The only thing is we are waiting for the Premier to sign. All we can do about that is continue to write letters to our members of provincial parliament and advocate for the signing of this bill. That's all that we can do, and that'll be it for today. Thank you for watching. Thanks for your time.